Welcome, legal warriors. I'm here again to talk about another area of criminal law in Washington State, and that's the crime of harassment. Are you charged with harassment? Are you just interested in what the crime of harassment is? Well, if so, this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes for more than 20 years, and I'm putting out these videos to help educate the public. So let's talk about the crime of harassment, and I'm going to talk about misdemeanor harassment. Now, I'm putting the statute right here on the screen in front of me. It's RCW 9A.46.020. And harassment can be a felony or a misdemeanor. And in this video, I'm going to cover three things. How is harassment defined? When are we likely to see harassment charged? And how can we defend the charge of harassment if you find yourself in that situation? So harassment, think about it this way. It's making a threat to another person to either injure them or to destroy their property, harm their property, or to you threaten someone else. That's one we don't think about a lot, but you threaten another person. Hey, I'm going to beat you up. Hey, I'm going to break your car windshield, or hey, I'm going to beat up your brother or sister. So that could be a crime if you make that threat, if the person threatened reasonably believes that the threat is likely to be carried out. So the state has to show two things to show someone guilty of harassment. One, a threat was made to injure somebody or somebody's property, or you can also do it for confining someone, but I've never seen that case. So one, there was a threat, and two, that the person threatened has to reasonably believe the threat would be carried out. And in most cases, this particular crime is not a felony. It's called a gross misdemeanor. That means the maximum penalty is 364 days in jail and a $5,000 fine. Now, there are some times when there could be a felony charge, and we've covered felony harassment in another video, but think about felony harassment as a threat to kill, or if you've got a prior harassment conviction against the same person, or some other exceptions that are written in the statute. So if you threaten someone and they reasonably believe it could be carried out, then you could get charged with harassment. And so where do we normally see these cases happen? Again, we've been handling this type of case for 20 years. What's the typical case? Well, a typical case would be that a boyfriend or girlfriend threatening the other. In other words, hey, I'm going to beat you up because of something that you did. And that person calls the police who was threatened. There was no assault, or you might get arrested for assault, but there was that threat. And sometimes the suspect says, yeah, I threatened the person, whatever. Well, that could be enough for the police to arrest the suspect for harassment. And usually you're going to get taken to jail for that. In that example, that would be harassment, domestic violence, because it involved a boyfriend and girlfriend in that hypothetical. Another situation we see is the dreaded voicemail, right? So you're upset, you might be upset at a business. They've done you wrong, and so you call them up on the phone, they don't answer, and you make some type of threat. Hey, I'm going to come down and bash out your windows because of something that you did. Well, why that can get charged is sounds like a pretty credible threat, and also it's on voicemail. So the police are going to be more able to prove it if someone can testify that that would be the voice of yourself or whoever's making the threat. The final situation we often see is the bar situation. We've had too much to drink and we're out and about, and there's some type of scuffle or almost scuffle, but an officer can't make an arrest for an assault, but they can make an arrest for a threat, some type of threat that caused someone to call the police. And so we see that case quite often as well. And more often than not, harassment charges end up in a physical arrest because officers are trying to, find a way to separate the parties. That's what police officers often do. Police officers are usually trying to find a way to deal with the situation at the time. And if there's not an actual physical fight, harassment is a pretty common charge an officer can rely on to try to get someone, taken away under arrest. Another one is disorderly conduct, which is sort of using fighting words, but sometimes that doesn't apply in a harassment type situation. I should also mention that It's not just words, it could be words and conduct, place someone in fear that the threat's going to be carried out. And so I've seen that, with guns and stuff like that, where someone shows a gun, and that could be harassment because of the implied threat with a gun. So thanks for staying around this long. As far as how we defend these, if you're charged with this, that might be what you want to know. And so the most important thing to realize is that harassment charges are defendable for the most part because of that second prong. Did the person threatened reasonably believe the threat would be carried out? And that's where we have a lot of ability to assert a defense, saying, hey, why there was a threat? Not every threat is a crime. Okay, so let's say there was a bar fight or a bar situation, almost a bar fight, and one person's popping off to the other, hey, I'm going to kick your butt, something like that. Well, if that other person doesn't go running away, and let's say it's a third party who called the police, it wasn't the person threatened, well, did that person reasonably believe that the threat would be carried out if they didn't flee from getting threatened, or they didn't call the police themselves? Well, that's usually a very viable and successful defense in that type of situation. The same way with a voicemail. Let's say the example I used before. I'm going to come down and bash out your windows. Well, did the windows get bashed out? Was that reasonable that that person who owned the business would fear it? And so there can be lots of ways to use that reasonability to defend that type of charge. Because if you're facing this, you're probably afraid, you probably lost your cool, and or you just didn't even make the threat, and you want to know how we might be able to get you out of this and keep you from being convicted, and keep it from being on your record. Another way that we can defend these is that the threat was conditional. It wasn't really a threat. I mean, that's really a pet peeve that I have when I see a harassment report. We might see a supposed threat like, if you take one more step towards me, then I'm going to do X, Y, or Z. Well, so is that really a threat? That's sort of like defending ourselves. That's conditional, right? If you call me again in the future, I'm going to come down and sort this out with you. Well, is that truly a threat? Because that's only if that person continues to do what they're doing. Is that going to be the threat carried out? So that's another thing to think about. Was it a direct threat, or was it something conditional where actually you're just trying to let the other party know to stop doing something? And it's pretty bad when you're trying to let your feelings be brought across that you want this other party to stop doing something, and the method of you saying it gets you arrested for a crime when you feel like you're the one who's been aggrieved all along. So how do prosecutors think about these cases? It depends. I think they're not taken quite as seriously as some other cases, depending on the nature of the threat. Usually it's a one-off situation. Oftentimes the parties aren't going to know each other again unless it's like a dating or a domestic violence situation. So what we might have a client do in these situations is do some type of anger management class. Do something to get some education to say, hey, maybe there's a better way I could deal with my emotions next time. Maybe I can sort of correct my own behavior. So prosecutor, you don't need to be so hard on me. You don't need to convict me and make me lose my job and do stuff like that. Additionally, if anger management isn't enough, sometimes we can try to resolve it with the other party. Harassment charge and that's not domestic violence could be resolved as a compromise of a misdemeanor, where we get a alleged victim to sign off saying they've been civilly satisfied for any damage that they have, and we're going to put that video about compromised misdemeanor up right here. But we could get them to sign off on something, say they've been satisfied, and then we could make a motion with the court to try to dismiss it. So you can see if you're charged with harassment, it's not a hopeless situation. There are things that you can do and your attorney can do to try to get you through the situation. What you don't want to do is just forget about it, just ignore it, and also realize that if you got arrested but you're not charged right away, that doesn't mean it's over. Typically, a prosecutor has 2 years to file a non-felony harassment charge against somebody. So if you've got arrested or you're being investigated for it, or you have a court date, reach out to an attorney. You can reach out to us, and there's lots of other good law firms out there that hopefully can listen to what happened and see what can be done to help your case. So if you found this video helpful, please like and please subscribe. It'll help us get more of this information out there to the public. And again, if you're in this situation, feel free to give my office a call. Again, my name's Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. We've been defending people charged with harassment for more than 20 years. Hopefully we can connect. We can listen to what happened. We can identify a way forward, and we can try to get your life back to normal. Thank you so much. We'll be there for you.